Good evening, everybody. Happy New Year. Welcome to our new season of Reasonable Doubt. I'm your host, Jimmy Ardwan, and to my left here is my co-host, Julio Vela. Julio, did you have a good holiday?
Very good, Jimmy.
Excellent. Glad to see you're back for the new year.
Oh, I'm loving it, man. Loving it.
Came back ready and fighting shape?
Oh, are you kidding? UFC
Drop those
style.
holiday pounds?
I'm ready.
We got a lot of good stuff to get to tonight. We're going to have updates on the Sandra Bland trooper indictment that just came down yesterday. We'll talk about open carry, the new open carry law that went into effect January 1st. We'll also talk about the affluenza teen and his mother being brought back to Texas and what's next for them. We got a whole lot more on tap with our guest tonight, HCCLA President JoAnne Musick.
Hello.
JoAnne, happy holidays.
Happy holidays to you. They're almost over, I guess.
They are almost over. I guess we're technically out of the holidays.
I'm still counting on the holidays, so.
And we have MLK Day coming up.
And Valentine's.
Valentine's.
You know, holidays all year long.
And our other guest on the panel tonight is board-certified DWI lawyer Doug Murphy. Doug, thanks for joining us.
Happy New Year. Glad to be here.
Absolutely, absolutely. We thank all of you joining us at home. We will open up our phone line, 713-807-1794, starting at 8:30. And we'll take your questions and comments live here on Twitter at HCCLA_TV, right there on Twitter. Also, if you want to, please go check out our website, www.hcclatv.com. You can catch our live feed. We hope you're watching it from there right now, but tell your friends, get them to go over there. We got a lot of great blog posts. JoAnne, of course, did a really good blog post for this week's show. We also had Pat McCann do a great blog piece this week. So there's a lot of good information for those of you out there who want to get some really good information on the criminal justice system, a lot of great opinions from a lot of well-known and very, very experienced and opinionated lawyers in our group. But guys, I want to start off tonight with the Sandra Bland case, the indictment that came down yesterday evening, and the trooper in that case, Insania. He pulled over Sandra Bland, of course, for making an improper lane change, and we've talked about this on the show before, Julio. We've kind of gone into this, but last night an indictment was returned for perjury, and don't have a copy of the indictment yet. Obviously, the case just broke last night, but as I understand it, there was an affidavit that was attached to his offense report, talking about he pulled her over to further conduct and removed her from the vehicle to further conduct a traffic investigation, a safer traffic investigation. The grand jury, of course, we know now, found that to be a false statement when they reviewed the video and all the other evidence in the case. And they indicted him for perjury, not aggravated perjury, but a misdemeanor, Class A misdemeanor. And I know there's a lot of people out there right now who are kind of likening this to when the federal government indicted Al Capone on tax counts instead of all the other stuff that he could have been charged with. But this is, I think this is kind of a big deal that a police officer gets charged for making a false statement with regards to an affidavit. That's something we rarely see.
Well, and do y'all know that he was no billed on something else, and then true billed on the perjury? So I think, or not that particular officer, but he's not being indicted for the death of Sandra Bland, right? Is that right? Or can you expand on that and what he actually is indicted for and what penalty ranges the Class A might come with?
My understanding is that when the grand jury originally met and considered indictments relating to the death, he was not considered as any party or implication or any involvement in the death. So he was neither true billed nor no billed at that point. He just wasn't part of that investigation. And then it was in a subsequent grand jury session that that the indictment was issued for the perjury. It is interesting that it becomes a Class A perjury instead of an aggravated perjury. He's lied in a governmental record. We see that all the time, charged as a tampering with a governmental record, which is a felony. We also, if it was an affidavit, it's sworn testimony, so it ought to be aggravated. And then if you have just regular perjury with intent to harm and defraud, that can elevate it as well. And surely he meant to harm or defraud somebody. So I don't understand why we're only looking at a misdemeanor in this particular case. Maybe the grand jury is just being cautious because he's a law enforcement officer. We see that a lot here in Houston. officers will get the benefit of the doubt and they'll get the lesser charges. So possibly that's, at play here is just the mere fact that he's a law enforcement officer.
What's the difference? What makes something aggravated perjury versus a felony versus just perjury, a misdemeanor?
It's the perjury under oath or in an official proceeding. And certainly the offense report is part of an official proceeding and it's part of the investigation.
But I think JoAnne, the main thing here that really should have perhaps maybe bumped it up to the aggravated is the fact that there was an affidavit, because I think if he had just put this in his offense report, then the question becomes whether it is actually misdemeanor perjury. But this is with regards to the affidavit, and that's the sworn statement.
Right, and
it becomes material in a sense.
And
because
a lot of times what DPS does in particular, and we've all seen this in DWI cases and whatnot, DPS always incorporates that affidavit by reference into the offense report. So I think you do hit it there when you say if they say he lied in the affidavit is sworn testimony, that ought to be aggravated in and of itself. And if it's been incorporated into the offense report, you've now also tampered with a governmental record.
Well, and Doug, you see a lot of this in DWI cases because you've got a couple different things there, especially nowadays. You've got the administrative, the peace officer's sworn report.
Correct.
And you've also you've got a lot of officers giving affidavits to get blood warrants.
Absolutely, and it really underscores the importance. Why is he filling out this affidavit? Obviously, it's done as a part of this investigation in the death of Sandra Bland. So there's one thing, and I think that would certainly make it material. It also reminds me of the fact of the attorney up in North Texas that was indicted about 4 or 5 years ago when he certified an expunction petition, and there was some information contained within the petition that wasn't correct. And it wasn't intentional, but it was a mistake, and he was indicted for perjury, and it was felony perjury. And so that really underscores the difference on how regular citizens or lawyers are treated versus how public officials are treated.
Do y'all think this was kind of splitting the baby or kind of a compromise where, okay, no one's going to be held for the death of Sandra Bland, no one's really responsible, but this is we'll go ahead and indict the officer of perjury? I mean, I don't know. It kind of smells like that to me, but what do y'all think?
Well, that's what I think kind of happened. I'm not sure it's a compromise, so to speak, but I think they found the falsity in the affidavit and then gave him the pass and gave him the misdemeanor because they probably, like everybody, believed his conduct was so egregious that he deserved to be disciplined in some way. And really, you can't hold him responsible for the death. That was at her own hand, apparently, in the jail. But, from his perspective, he should be accountable for something, but I think they gave him the pass by making it a misdemeanor instead of a felony.
Well, they obviously looked at the evidence, they reviewed the videotape and compared it to the affidavit, and the two don't match up. And
That's a falsity.
This happens day in and day out in DWI cases, and now hopefully with the advent of body cameras being utilized more frequently and just the run-of-the-mill criminal cases, I think we'll see that, and hopefully these body cams will help conform behavior on behalf of officers that would be more what the public expects.
I'm going to go out on a limb, though, and say that all of us sitting at this table don't expect a rash of perjury indictments coming either in Harris County, Fort Bend, or Montgomery for
you mean
the affidavit. False affidavit.
They are a rarity.
You mean the government holding responsible their own agents?
Yeah.
Oh, yeah. No. But let me ask you something, Doug. Are you seeing more HPD body cameras or body cameras in them, and are you seeing them more in cases?
I haven't seen them with the Houston Police Department. I've seen them with other agencies, not so much in this Houston metro region. Bryan College Station, I've had a couple of cases up there, and I had 4 hours of videotape on one misdemeanor arrest. Happened to be a DWI with 3 officers, body cams from every angle.
Wow.
At the scene, at the station, at the hospital.
Are the body cams equipped with microphones, and are they? I mean, I'm not saying are they shot in HD, but are they visible or?
Fantastic visual and audio
Really?
quality.
Wow.
Really, really good quality.
Both good and bad potentially for your case.
It can hurt and help. Double-edged sword, no doubt.
Well, we're going to watch this case for sure. It should be interesting to see how this perjury case progresses and what possibly could come next. I think the grand jury's closed down their investigation. So this looks to be the lone case coming out of Sandra Bland's death. Kind of strange. I know we still got the civil lawsuit coming on, but this looks to be the lone criminal case. All right, I want to turn to the big issue that took effect here January 1, and that's the open carry law here in Texas. It of course went into effect January 1st, and there's been all sorts of controversy. I know I saw today there was a barbecue restaurant out in Cyprus where the owner was threatened by someone who doesn't agree with open carry. The owner of the restaurant said, I'm going to allow open carry in my restaurant, and I'm going to give a discount to those who open carry or concealed carry. And then he receives a threat on Facebook, of all things, from somebody who's clearly against this policy but threatens to come shoot the place up. I mean, it's
kind of ironic there.
Yeah, kind of ironic. But JoAnne, you
Thanks,
wrote
Obama.
Yeah. JoAnne, you wrote a very good piece this week on our blog. You can go to HCCLATV.com to read JoAnne's blog piece this week. But your blog piece focused on the advisory opinion that came out before Christmas from the Harris County DA that advised law enforcement officers how they are to approach people when they are open carrying. And for those who maybe don't understand the law or don't understand what it means now, kind of a basic synopsis is before you had to get a license to carry concealed in Texas. And this doesn't apply to long guns, as long guns have always been able to be carried open in Texas.
Well, what are long guns, first of all?
Rifles. Shotguns, rifles, the ubiquitous AR-15s, AR-10s that everybody loves to hate. But your concealed handgun license is now essentially a license to carry, whether you want to carry open or concealed. You still have to go through the background check, you still have to go to the training, but if you have this license, it now gives you the option to carry open or carry concealed. And so the question becomes in the law, as you point out in your blog piece, JoAnne, is what happens when you come into an encounter with police officers if you decide to open carry?
Well, let me start with the open carry legislation does say that when a police officer requests your license, you must display it to them. So you're supposed to carry your license with you at all times, and if an officer requests to see your license, whether you're carrying concealed or open, you're required to produce your license under the statute. That particular statute has no remedy or penalty for your failure to display the license. It does not say, well, if you don't show us, you'll lose your license or your license will get suspended like we see in DWI type stuff. It just simply says you'll produce it. Everyone agrees, and there was a huge debate in the legislature when they were in session over whether or not police officers could just come up and say, show me your license, Jimmy. I want to see it right now. Clearly, an officer can come up to anybody and say, hey, Jimmy, I'd like to see your license. It's called a consensual encounter. If you consent to that encounter and we exchange pleasantries or what have you, it's just a consensual encounter, and if you decide to show them your license, great. To go beyond that, to require or show a police presence and require your answer, the police need reasonable suspicion to go beyond that consensual encounter. So if you're no longer consenting, we need some reasonable suspicion to get there. The district attorney's memo says just failing to show the license should rise to reasonable suspicion at that point, which is kind of interesting because if you're legally allowed to carry it, how can failure to show the license by itself with no other factors become suspicious?
And this is where it has become evident that this is a poorly written law and has put a lot of people in kind of this quandary of what do we need to, what should we do? How do we do this lawfully? And what are our rights? I think that's the big thing that comes out of this, as you point out, and reading your article and reading this advisory opinion that's also attached, nobody really knows what to do because it's such a poorly written law.
So according to Ms. Anderson, so then you get detained?
Yes, according to her memo, is that you would get detained because that's reasonable suspicion. The officer can now force you to present your license or run you on the computer or whatever to see if you have a license. Now, she does say and clarify in her memo to law enforcement that should you come to find out that the person does have a valid license, most likely, the DA's office will not accept criminal charges in that case because there was a license. But you're going to go through this detention against your will, which is a Fourth Amendment search and seizure issue. You're going to go through this detention for the officer to check it out and see if you have a valid license. You know, it really is an open question, and I can't say that we're 100% right, but I know even the legislature talked about whether or not we should whether or not they should draft the language. There was an amendment that said, you know, officers may not stop a person solely to inquire about their license.
Well, and that's case
and that
law.
was struck. Well, but that amendment was going to be in there, and then it was struck because everyone said, we don't need that. Everyone knows the Constitution protects you from that detention and that encounter with the law enforcement. It's either consensual or it's not, and they have to have reasonable suspicion. So even our legislature said, we don't need that extra language in there.
Yeah, this new law has really whipped the public into a frenzy. It's got businesses concerned about whether or not they're going to allow these people to openly carry, even if they have a license, whether or not they're going to reject those people, what they need to do to follow the law to exclude those people from entering with open carry. And then also opening them and then protecting their customers. You know, the businesses are just scurrying, trying to figure out what to do.
Yeah, I mean, people are debating whether or not, because Kroger is allowing open carry, but HEB is not, and people are, you know, on social media boycotting Kroger because they don't want to. They want to be part of walking up and down the aisles with guns displayed.
And then I saw something, I didn't get a chance to finish reading the article today, but Walmart is supposedly saying that you'll be required to present your open carry license if you're open carrying in there. And it has something to do with, they believe because they sell alcohol, they're required
The
to ask.
51% rule.
Yeah.
Yeah.
But that's not 51% of
I doubt that
Walmart's
Walmart derives
business.
51% of their
Right.
sales from
I
It's not a bar. It's-
I buy 51% of my 51% from Walmart. So. No, but so what happens when you go into a store and you don't know if it's not open carry and I'm open carrying and am I going to get arrested? Am I going to get charged for unlawful carrying of a weapon or what's?
the businesses have to
The
display
business
it.
got to tell you at the front door, and it has to be at every single door. So you should never be able to just walk into a business and not know.
There's certain language, there's certain font type, certain font size that they have to follow in order to be able to exclude people from the premises with an open carry.
You know, so then who's in charge of telling the guy with the gun he can't come in?
Well,
The guy with the bigger gun?
The guy with the right? I mean, and then the guy with the other bigger gun comes, and then the other guy with the other.
Quite
bigger
frankly, I'd rather tell the guy who's concealing.
gun. Yeah.
yeah. Well, and I know myself and JoAnne, we both have our concealed handgun license, now our license to carry. I mean, do y'all have one?
I do. I've never concealed carried.
I only carry shotguns.
Stick to the long guns and you're
It's the
good.
long guns, man. AK-47. No, I don't even own a gun, so.
You're a duck hunter?
No, well, I'm a Buddha.
But I mean, I think the practical thing is, I mean, three of us here who are CHL holders. If a cop stops me and asks me, I'm going to show him my license just because I don't want the hassle.
Yeah, and I think that's what it really comes down to is most people will simply say, oh yes, here's my license, because we know we're not doing anything wrong. You know, it's not a show of authority necessarily at that point, but if things get ugly, you know, I'm not going to sit on the side of the road with a police officer who is attempting to detain me longer than necessary. You know, if he crosses that line, I'm out of there.
This brings up a very good case that I just worked on that eventually resolved favorably, where there was a wreck. Okay, African American male. He's trying to change his tire. He got in a little fender bender. Officer comes up and says, "Oh well, it looks like you need to get your car towed." And he's like, "No, you know, I think I'm gonna be okay. You know, maybe we should get a tow, maybe not." But the officer ends up deciding that this guy needs a tow. But in the process of that, he starts searching this individual's vehicle. And the individual is saying, "Hey, dude, you cannot search my car. Do not search my car." And the officer says, "I'm going to search your car. I don't care what you say." In any event, at the end of the day, the officer searches the car top to bottom, finds no drugs, finds no weapon, other than the fact that it's an African American male in what would be claimed as a suspicious part of town. This individual gets arrested for interference with the public duties. There was no reason, based on inventory policy and tow policy, to end up having to tow the vehicle, not allow the individual to get his own record, and then to search his vehicle. So it's kind of the same deal. I'm kind of thinking that we might end up having to see cases where an individual is going to interfere with the public duty when the officer's asking for his, concealed handgun license, but this guy's saying hold on, man, I'm a license to carry, I'm fine, but then ends up getting arrested for interfering with public duties, or maybe he mouths off to the police officer after the police officer has nothing else to arrest him for.
Well, you always get arrested for pissing off the police. You know that.
I think that's
Attitude is certainly going to play a major role on both of the officer and the citizen.
Well, and just from a practical standpoint, my personal opinion is that I wouldn't open carry anyway. Especially in this environment, you're begging for problems. And I understand the people that want to do it. They believe they have a constitutional right to do it. And I'm a gun owner, I'm a CHL holder, but there's a point where proving your point can cause more problems.
Right to carry doesn't mean right to use in every circumstance.
Exactly.
Citizens have the same right to utilize a gun as police officers do. Most of the public doesn't know that. Coincidentally, I was at a place called the Burger Shack back in November, and they had a sign that says, "Guns are welcome on premises. Please keep all weapons holstered unless the need arises. In such case, judicious marksmanship is appreciated."
Wow. Let me throw this hypothetical out there. Okay, so what happens when an officer approaches the individual, asks them for their papers, they're licensed to carry, but then the officer says, "I smell alcohol in your breath." Are you able to carry that pistol? And then if the officer decides that you might be a danger to yourself or others because he thinks you're intoxicated, and if so, what are you arrested for? Unlawful carrying?
Well, I think at that point, you've just set it up. When the officer says, "Can I see your license?" and you start to engage in that little bit of conversation and he smells alcohol, boom, you've got reasonable suspicion right there to believe that there's a crime afoot or something. Because you cannot be intoxicated in an open carry or concealed carry. You can't have a gun while you're drunk.
So could we start to see cases where the intoxications, as we see in DWIs, are now going to be whether or not you were intoxicated at the time you were carrying?
Well, I think you definitely will. We see that with DWI cases now where people get charged not only with DWI, but also with the unlawful carrying of a weapon. And we see that frequently. The weapon gets confiscated, they get charged.
That's interesting.
Somebody had it in the car and they're lawfully allowed to have it in the car unless you're intoxicated.
Right.
And I think the intoxication standard is in public places if you're a danger to yourself or others. I don't think it's like there's no .08 while you're carrying other than driving, right? There's no like .08, or are they going to be giving individuals standardized field sobriety tests while they're that's interesting. I haven't thought about that.
I think they'll probably utilize the public intoxication standard, which, as we all know, is when you become intoxicated where you become a danger to yourself or others. But truthfully, you've used a bad attitude towards the officer most of the time, unless you truly are a danger to yourself or others. But you have certainly pissed off a police officer.
Wow.
And that will get you a trip downtown.
So, on the heels of all this, guys, President Obama, of course, issued his executive order to close the gun show loophole this week. Expanding background checks, which drew quite an interesting tweet from our Governor Abbott, where he basically said, "Come and take it," and I'm not sure what that means. Come and take it. The NRA 16 years ago was advocating for expanded background checks, just the very type that was ordered yesterday as part of this, and so I'm kind of confused as to what the "come and take it" means exactly. You guys got any insight on that?
I just think it's political rhetoric. We are Texas. That's our motto. Come and take it. You want our guns? Come and take them. I think that's really what it comes down to. It's just the show of pushback there.
Right. JoAnne's exactly right. It is just a political forum. It's obviously a very popular issue amongst the conservatives. It's Governor Abbott pleading to his constituents, and he's going to get their support. And if he does that, he's going to get it. Now, what's interesting, this executive order outside of what you just mentioned really doesn't expand gun control. And the truth is we don't need more gun control because the people that have committed these mass murders in these schools and public other places, they're already violating the law.
Right. One of the loopholes there was a number of things that the executive order did. So one of them was a loophole where okay, well, let's say I'm not allowed to have a gun. Let's say I'm a felon, and I create this gun trust or a business, and through this business, I can purchase the gun. Now, the way the law is currently set up is that if the gun trust or the business purchases the gun, I don't have to get the background check. I don't think any of these people who are committing these murders are as sophisticated to create the gun trust and go buy the AK-47 and then use them as a weapon of destruction. So that's one loophole that was closed. Now the individual, whoever's creating this gun trust and anybody who's holding these guns in the gun trust or the business is going to get a background check.
Well, and I think, Julio, the gun trust issue was really for what they call Class 3 weapons. You talk about the destructive devices, the suppressors to silence and limit the muzzle flash from guns. That's really what the gun trusts were designed for. You've always had to get a background check. Gun trust wasn't able to purchase guns, and in fact, on the federal firearms license side of things, if you want to go out and obtain, if Doug, JoAnne, myself, or you want to go out and get a federal firearms license to sell firearms, we can't just use that license for our own personal gain. We can't just use that and say, oh, we're going to acquire guns at a discount from the manufacturers. You have to actively be engaged in the practice. And one of the things that was interesting was they were trying to close the loophole on online sales. Mm-hmm. And it was kind of like they realized, well, wait a second, because the law actually says if you're going to buy online, you have to go and pick it up from a federal firearms license holder. The online retailer has to ship it to a federal firearms license holder, and the purchaser has to go pick it up, and that federal firearms license holder processes the background check.
Right. It's not like you're ordering it online and it's showing up by FedEx at my front door.
Exactly.
It's sitting out there all day till I get home.
It's not like eBay for guns.
It's not eBay for guns.
No,
Exactly.
No. I mean, that's the. I mean, I'm not. Look, I'm a gun supporter. I'm a gun owner, and I do agree that some of this is necessary. I don't really like the governor's take because I think it gives gun owners a bad name to come out and say stuff like "come and take it." I mean, but I agree with you, Doug, in the sense that the people who are out there committing these mass murders, they're going to go get those guns. They're going to find. It's just like the war on drugs, which we know has failed. The war on guns, if they want to go that route, is going to fail, in my opinion, because the people who want to commit this stuff, they're going to find a way to get it.
Those laws are really going to affect law-abiding citizens who are hunters, people that engage in firearms shooting competitions. There are Olympic sports where those Olympians have come out against the executive order. Obviously, we all want to eliminate the gun violence that's taken place, but we also want to balance our right to carry arms, very important, and there's a very good reason why we have those rights. And obviously, as Texans, we're very fervent about those rights.
One of the other things that the executive order did was allow states to share more medical information to the federal government. So, for example, if I'm in the state and I have some sort of mental health issue, currently, the FBI and the federal government sometimes has difficulty speaking to the states who have some of this information if they're receiving state aid based on some sort of mental health issue or mental health illness. So now the executive orders, and it is where it comes into conflict with HIPAA, the government is saying, look, I really don't care about HIPAA, or to a certain extent, we're just going to say, I need that medical information. So the government can start to collect medical information on individuals who might have mental health issues or might not be fit to carry a weapon. So
there are certain exceptions within that HIPAA law that allow the government to maintain access or access that information. These gun laws came to be back in the 80s when the assassination attempt on President Reagan, and I guess it was called the Brady Bill, and they put that up because I believe it was Hinckley had a history of mental illness. And so certainly we've got to weigh that and balance it.
Well, and Texas already does somewhat of a mental health background check on you when you apply for your CHL or your license to carry. So Texas is already doing that, at least on the licensing. And then we're just talking about how much of that we're going to add into the federal system so that when you go to purchase a gun or other, they can know that same history.
Let's highlight the benefit of the Texas open carry law. It requires the license. It requires training. It requires you sit through a class. There's another state in our union, Arizona, does not require them to have a license to open carry.
Wow.
You talk about the open. Wild West.
And they just arrest Mexicans willy-nilly, is what I understand. I swear, I thought you can. Yeah, I thought they could over there.
We've hit the halfway point of our show, so I want to take a little bit of a break. We're going to run our 60-second law segment this week with Eric Nelson. But when we come back from the break, guys, not only are we going to open up our phone lines for our viewers, 713-807-1794, but I'm going to want to talk to you guys about this Oregon militia standoff that's going on right now in conjunction with this. But right now, our 60-second law lesson with Eric Nelson.
This is Eric Nelson, and over the next 60 seconds, I'm going to tell you what to do if an officer calls and asks for a meeting. The most important thing to remember is that this is part of a criminal investigation, probably targeted at you. So you want to find out from the officer why he's calling you and what he wants this meeting to be about. Remember, the officer is probably recording this conversation, so don't say anything you wouldn't later want to hear at trial. If you do decide to take the meeting, do so in a location that's comfortable to you. Your home, for example. Don't go to the police station where you may feel threatened or intimidated by the officers. Any conversation between you and the officer at this point is going to be a consensual encounter. So the officer does not have to read you your Miranda rights, and you do not have to answer his questions. You also don't have to explain why you didn't answer his questions. However, don't lie to the officer, as this can get you in trouble down the line. You may leave at any time during these meetings, so if the officer makes you feel uncomfortable, do that. The best solution is always to call your lawyer. If you can't do that, use these tips. My name is Eric Nelson, and this has been your 60-second law lesson.
Thanks, Eric. Great advice. Kind of echoes what JoAnne was saying earlier. If you want to recommend our 60-second law lessons to somebody, if you want to view Eric's lesson and all the other lessons we have them up on our website, HCCLATV.com. You can go there and see them all. We're going to open up our phone lines right now, 713-807-1794. We also got Twitter up, HCCLA_TV. Send us your question and comments for JoAnne Musick, Doug Murphy, Julio Vela, and myself. Okay, guys, I want to talk about this Oregon militia standoff because it's got a lot of interesting layers to it in the sense of these ranchers. This is on the heels of the Cliven Bundy matter out in Nevada, which was a dispute on grazing lands in Nevada and whether or not grazing fees were being paid to the Bureau of Land Management. So we have the same issue out in Oregon. There are a couple ranchers who ended up going to federal prison over this, and that's what has sparked this controversy where a bunch of other militias have come and taken over this wildlife building, this federal wildlife building. And of course they forgot food, they forgot toilet paper. It's become this whole thing, but a lot of the controversy centers around the fact that they're an armed militia, they have taken over a federal building, and the federal response, the response by law enforcement has been reserved because the implication has been that we have white militia members, and if they were of another race, that this situation would be treated differently. I want to get y'all's opinion because I have a little bit of a different take on this, and I think this stems from the fact of a sordid history with the federal government and going in against militias. We've seen it in Ruby Ridge and we've seen it in Waco, and those had nothing to do with minority races. Those were both white militias that ended in deadly conflict where a lot of lives were lost, a lot of law enforcement lives were lost, and ultimately ended in expensive trials that resulted in not very good results for the federal government over it. So I kind of want to get y'all's take on that issue and how it plays into the larger gun issue we've got going on here.
Well, I'll add my 2 cents. I think you're right. I think federal government, federal law enforcement, it's a little gun shy to, not to make too much of a pun out of it there, but, this is an armed militia that's taken over a building, but there are no hostages. There appear to be no citizens in danger at this point. They're simply held up there, sort of camping out. And when you look back to Branch Davidian and that sort of thing, you see the federal government trying to ambush and get in there, and that just really blew up in their faces. Mm-hmm. And so I think they're a little gun-shy about just storming the Capitol there and going into the wildlife refuge to when there's not a particular harm right now. You just really have a group that's kind of squatting there and exercising their right and kind of saying screw you to the federal government, but they're not really harming anybody at this point.
Right, it's obviously not a very well thought out plan on their part.
No.
There's actually zero planning in implementing whatever it is they're trying to accomplish. But hopefully the government's learned from their lessons of the Branch Davidian case and Ruby Ridge. And I think if common sense approach would be, hey, they don't have the necessities they need, we can wait this one out, and it will.
Then we'll eventually arrest them and prosecute them.
Right.
Most likely.
It seems like they're trying, in this case, they're trying to come to an amicable end to this, instead of what we've seen amongst local law enforcement, which is shoot first and ask questions later.
Yeah, and it certainly seems that way in this case. There's just sort of, we'll wait it out. You know, they don't have the supplies and the amenities there to sustain themselves. We'll just kind of wait this out, and we'll attempt to negotiate with them a little bit and see if we can't come to a resolution that keeps everybody safe. I really and truly don't see that this has anything to do with whether they're white, black, green, or yellow. You know, it's a mere fact that there are no hostages or citizens' lives at risk. There's not even like neighboring homes or whatever that are at risk. So it's not like we have a standoff in a residential home where the neighbors might be at risk. We have a federal facility that has at least enough land around it that we don't have that sort of interplay with other citizens.
Right. We got a phone call. I want to jump on the phone line and take our first phone call of the night. Hello, welcome to Reasonable Doubt.
Oh, thank you very much. I understand, and I've read recently that there's a. Can you hear me?
I can hear you loud and clear.
Okay. That there's been an attempt to put defense attorneys in the 1517 probable cause first appearance of an accused alongside the prosecutor and the magistrate. Why isn't there a bigger fuss about this? This sounds like like an abortion of justice here, without having a defense attorney in the same room with the accused and the magistrate.
Yeah. Thanks for the call and thanks for the question, JoAnne. I know you wanted to jump in on that.
Yeah, I actually
okay,
do. We've known for quite some time that this is potentially an illegal practice, where the courts in Harris County are holding these probable cause dockets without the accused having legal representation. As early as 2009, the Justice Management Institute came into Harris County at the request of the Harris County Judiciary, did a study, and this was one of their recommendations, was to place defense attorneys in those hearings. And then everybody got caught up in the logistics. Well, how do we get the right attorney there? You know, if we have court-appointed attorneys, do we get them down there on call, or do we have, for example, Julio stand in today, but then Julio becomes the attorney, so now how do I sub him out and put a different attorney on once this person gets to court? They kind of just got bogged down in the logistics and never made it happen. They have all these great excuses for why it won't work, and that it'll take too much time and it'll slow down the process. Alex Bunnan, our public defender here in Harris County, has been leading this cause for years, even before he was the public defender here. He's seen it work in other jurisdictions. He's been pushing to have it started here. He's offered his office to be on sort of a 24-hour call, assign somebody to be there to at least sort of triage these cases. Identify your mentally ill, identify those that deserve or need PR bonds, help those individuals exercise their rights, and help them identify or find neighbors, friends, relatives, people who can vouch for them. We were talking about that before the show. A lot of times people get held and they go to these pretrial interviews, and if you can't give your address and 2 or 3 phone numbers for references and reference addresses, you can't get out of jail. You've got to be able to give those references, and then the county has to be able to follow up on them. But anyway, so we've had a big push for that for years, at least since 2009 when the Justice Management Institute recommended it. And now we see for the very first time today, Devin Anderson, our district attorney, spoke out and said, you know what, I think that's an important thing. And I think this is the first time we've ever had a sitting district attorney speak favorably on that point.
Yeah, I mean, it leads us into our next topic, and that is the press conference that was held today regarding the new MacArthur grant.
Well, and this got added into
Yeah.
the MacArthur grant in the 11th hour. It's a very small pilot, but it's been added to that grant with the idea of having a whole commission ready to go by March of this year.
What's this grant? What does it do?
Well, look, it looks to me, Julio, looking at this treasure trove of documents that we were able to get today. The target is to reduce the jail population. They have a target of reducing it by 20%, 1,800 people. And they give you a nice little chart and a nice little map, and there's a 8-page summary and everything.
This is wrong. Look, whoever made this, it's wrong.
Well,
Straight up.
Tell us why it's wrong.
It's
Julio.
wrong. This is a lie. Whoever made this map, I don't know who made this, it's wrong. Why don't you get attorneys who are down there every single day in the trenches fighting to draw a map for whoever did this? It's wrong. First of all, it says, oh, at your first appearance, if there's no PC, you get to exit the criminal justice system. But echoing what JoAnne has said is by that point, PC's already been determined without a defense lawyer. So this is your first mistake right out the gate. Secondly, it says, oh, well, you'll have your initial hearing and then you'll get to a trial. However, this line fails to indicate to get to a trial in Harris County in a misdemeanor court, you're looking 8 months to a year. If you're locked up in custody, that boggles the mind for someone to sit 8 months to a year waiting for a jury trial, much less if you're charged with a felony looking at a year to 2 years. Whoever did this is wrong.
I'm not sure you made your point clear.
I'm just saying, it's sick. This is the kind of thing that goes around, and you're making decisions based on this, okay?
I think the point is this. If you're holding somebody for 6 months, 8 months in a misdemeanor case when the maximum punishment is 6 months in the county jail or up to a year in the most severe misdemeanor case, we've got a real problem here. And the problem is at the very infancy of a case coming in before it even really becomes a case and not granting the use of a PR bond.
Yeah, they come out with a bunch of different solutions or proposed solutions to reduce the jail population. One of them being the PR bond, which that's been a topic that we've been debating here on this show and amongst the defense bar for years now. That they finally put it into some nice charts and a nice little summary is great, and that they might actually be considering using it on a more expanded basis. That's wonderful as well. But they also have announced an expanded pretrial diversion program. They want to add shoplifting and the so-called trace cases or the crack pipe cases, which of course the Likas administration refused to prosecute. And as we all know as defense attorneys, these cases, they should be dismissed. They shouldn't be prosecuted.
They shouldn't even be diversions.
Right.
At this point, I mean, yeah, I appreciate the step to get these people out of the system and give them a diversion, but they shouldn't be prosecuted in the first place. We're talking about residue amounts of a controlled substance, whether that's cocaine or meth or whatever, that's inside possibly a little glass tube. You can't even see it, much less potentially know that it's there, but you can be charged with knowing possession of that.
One thing the law is clear about, isn't it, Doug, about whether or not you know there's a substance in there and they can charge you?
Well, the case law is pretty clear. If it's a non-usable amount, won't be sufficient. But let's go back to the PR bonds. You know, here they are trying to utilize and obtain, what, $2 million grant money?
$2 million for 2 years.
Let me save the government $2 million and ask the Harris County Judiciary to create a new bond schedule and to look at certain misdemeanors with no criminal history to create PR bonds across the board. We don't need more fancy charts. We don't need any more meetings. We just need the judges to sit down and meet and say, okay, these types of cases, these misdemeanors with no criminal history, these people with ties to the community, obviously are going to have an incentive to come in and show and appear in court and fight the charges. It's very simple, and all this is just a runaround to obtain some federal grant money. Well,
and I think one of the things on the very first page of the summary that I think we can all agree is probably some misinformation to some degree is that second paragraph, misdemeanor offenders consistently comprise only 8% of the pretrial population. what's kind of lost in that statistic about the 8% is if you go down a little further, they talk about that the average length of stay for those who made bond was 3 days, and completing a misdemeanor jail sentence was 9 days. Well, guess what? The 3 days, most of the people have already got credit for time served before they've even, if they get arrested on a Friday, they've got their 3 days. They get out Monday after they've pled guilty in court. So, I mean, you've got this kind of revolving door, which, Doug, I'm sure you've seen this, but a lot of clients, they get the $500 bond or the $1,000 bond on a first offense DWI or a second offense DWI or a possession of marijuana charge. And even if they can make the bond, sometimes it takes them a day or two to get somebody to go over to the bonding company and sign for the bond, get the credit card processed and everything else. But these are people who can afford it, who can get out and fight the case. But those are the people that also, you could have just processed them in and processed them out, because these are the people that are going to show up for court to fight their case.
And I've had many times when they say, "Oh, I'm going to get a time served. Can you just call my girlfriend or wife? They're on their way right now to pay the bond." Like,
Tell them not to, yeah.
Yeah, it's like, don't tell them not to pay the bond. And it is a problem. And I want to say, going back on what Doug was saying, is that there has been slowly, and we're seeing it in incremental, by no means where it needs to be, movements. And I think it's part of the defense bar taking up the torch and leading the way, but also slowly but surely. And I will call it when I see them that there are more and more judges out there slowly that are starting to consider PR bonds. Not many, and what it takes is lawyers, defense lawyers on the ground level asking. There was I think in your blog it talked about there was a culture, or there is a culture of saying, nah, I'm not even going to ask for a bond reduction on the defense bar side, or no, I'm not even going to ask this judge for a PR bond. And I think that culture, through exposing this and talking to the public, is starting to change. Because I know as more and more defense lawyers who are becoming aware of the problem are starting to challenge. And more slowly but surely, some judges, not all, are starting to do PR bonds. And I'll call them out as I see them. Judge Stanley is starting to do it. Judge Goodhart is starting to do it. They are literally, I'm going up to them, I'm saying, this guy deserves a PR bond. This one does. And they are listening. I'm not saying it happens in every case, but it is starting to, slowly but surely. Now, on the misdemeanor level, fine, but when you start to get to the major felonies or felony level, I think that is the next step. I think that's where it needs to go.
Well, let me just add this about this whole safety and justice campaign through the MacArthur Foundation. I've been sitting and I've seen this table, this little chart many times. I've sat in on a bunch of meetings it's the Harris County Criminal Justice Coordinating Council that's leading this. Commissioner L. Franco Lee, who just passed away, may he rest in peace, and was the chair or the lead of that committee. I've sat in on a lot of meetings. We see through what the statistics they are presenting is that on any given day, about 60 to 75% of the jail population is pretrial detainees. Meaning these are people who are awaiting to go to court, awaiting a trial. These are not people who've been convicted of a crime. Okay, so when I think Jimmy's right when you say this second paragraph looks a little deceiving when we say, well, that's only 8% of the population. Well, maybe so, but why is that 8% sitting there in the jail? Why does it cumulatively count for 60 to 75% of the jail population on any given day? We see individuals like you point out, Julio, you're showing up in court and you're saying, look, my client deserves a PR bond, and you're getting some great judges that are giving those. Some. But it should have never gotten there in the first place. At probable cause court, within 24 to 48 hours of their arrest, they should have been given the PR bond there. Where you're talking about seeing them for a first appearance in court, we're talking a day to 3 days after their arrest. And we see even in this statistic, the average length of stay for a person who has made bond is 3 days. So they're sitting in jail 3 days just to make a bond. Now that's not a PR bond, that's any type of bond. That's a PR bond, a surety bond. Why is it taking so long to process these people?
That's a good point.
It should not take 6 to 12 hours to book into the jail. It should not take another 12 to book out. It should not take an appearance in front of a magistrate who denies it so that you can wait 2 days and get in front of the local, the elected judge and get the bond granted. This needs to back up and start at arrest.
Well, the good news is they are taking a look at this and trying to prevent this from happening. But stepping aside from the way how we do things, if you look at other jurisdictions, I'm talking about other states such as Arizona, Colorado, on certain offenses, they will be arrested, they will be taken down to the jail, they will be fingerprinted, the AFIS, and then they're cited and released to somebody. They don't have to get booked into custody.
Texas has that option available for some offenses, but Harris County refuses to utilize it. We have cite and release on the books. It's part of the law for certain low-level offenses like possession of marijuana. And we even saw that with, Devin Anderson's First Chance program with the marijuana cases. They're supposed to be given the opportunity to just sign up for this diversion program and be on your way. But only, I think it was 8 or 9%, or maybe 12, were getting that option. The rest were getting booked into jail, either posting a bond or showing up on their first court appearance and then given the program. Why are we delaying and not using these cite and release programs? Why are we not jumping on this at probable cause court?
I think I read one of the figures, it was $280,000 a day to house all the inmates at the Harris County Jail. That's a staggering figure, and you could cut a vast majority out of that and just let it be the pretrial detainees as you work and try to find a solution for that problem.
Yeah.
And I think, if I'm not mistaken, all those individuals who have, let's say, mental health or health issues, the health costs are absorbed by the taxpayers too. So, I mean, it's like mental health individuals should be screened better. They should be diverted. They shouldn't even be diverted. There should be a separate response for them. Individuals who have no criminal history or qualify for certain things to just be cited and released should. And at $280,000 a day, I think there's all sorts of things that can be changed.
Well, and you were talking, JoAnne, about the delay getting processed in and processed out and all that. I mean, these people, they have to go through medical. And if just release them. Don't force them to go through medical. Yeah. Determine that they are eligible for a PR bond and short circuit that whole need to go through medical processing and everything.
And you know what's interesting is, I hear clients, I don't know this, I don't have statistics on this, but I have clients tell me all the time that if they can get their families to post the bond while they're still sitting in city jail, they'll be out in a couple of hours. So HPD can process them in and out in a couple of hours. But if they hit the Harris County Sheriff's Department jail,
good luck.
You are easily 12 hours in, 6 hours out. So you're there an entire day, if not longer, if you've already posted bond.
What I hear is they're literally, it's like a nightclub. Like it's one in, one out. Or one out, one in. And so literally as people, we had 5 people be released today because they got their sentences. We can bring over 5 more people. So it's one out of the jail, one in the jail. It is that full.
Yeah, the morale at the Harris County Hilton is pretty low.
Pretty low. This is just the beginning, guys. I mean, we're going to have a lot more discussion on this. This is just the first conference on this, and we'll see how this stuff is implemented. But at this point, I'm a little skeptical of some of this stuff and how it's going to actually be implemented to work.
Well, the thing about it is, you're absolutely right, Jimmy, and I didn't mean to cut you off there, but this is all prepared and presented by the Harris County Committee on Criminal Justice. It's not saying that the judges are necessarily going to do it.
Yeah.
So that's the whole second step. We're dangling this out there and we're putting this proposal to try to get this $2 million a year for 2 years, total of $4 million, which is only a minute portion of our budget anyway. But anything helps. So, but are we really going to follow through and actually implement these things?
I guess the best news is they're finally talking about it.
That is
only because it's become a cost concern.
Only took 2 decades.
Yeah, it only took 2 decades.
I wonder who. I think Overstreet put his name in the DA race, didn't he?
He did.
And then so we have
Overstreet.
Overstreet.
Yeah,
and
Overstreet.
Morris Overstreet.
And then Devin, right? So I'm wondering. I mean, because they have a huge influence as to how this goes too. So
Absolutely.
I'm wondering to see how that pans out.
We only got a couple minutes left, guys. This hour's flown by. We didn't even get to talk about the affluenza.
Or the person who brews alcohol
Yeah,
in their
Doug.
stomach.
Okay, so I want to ask
this
you.
is a good
Doug.
one
We
for
got
Doug.
we
I
got
wanna
you
know
here
this.
because I want to know about this because I wanted to get to this. So, this story has been circulating the internet about this woman who got out of her DWI because her body brews alcohol. Is that really possible?
It is possible. It's a rare condition that people can have. The studies that I've read about, generally it happens. It's how our body metabolizes alcohol. And if you think about fermentation, you have to have two things. One, you've got to have sugar, and two, you've got to have yeast. When you get it in a warm body, such as the gut syndrome, the autogeneration of alcohol, the metabolization of alcohol gets broken down by what's a process called alcohol dehydrogenase. The studies that I've read, generally speaking, it's been in Japanese individuals because they lack an enzyme that helps break down this alcohol dehydrogenase to break it down. And also, some of us have certain yeasts in our body. And it's rare when somebody will have that, but it can. And there was a study in Baltimore where somebody was half the legal limit without consuming any alcohol. And then another individual was 1.5 times the legal limit without consuming any alcohol, just because they had some kind of an infection that also invited this yeast. Candida albicans is the most commonly referred to. This is a different type of yeast. Generally speaking, you see this type of fermentation in a vial when blood is no longer a living human organism, or you see it in a dead corpse, where there was the doctor who had the head decapitated in an elevator.
Right.
And then they tested his blood and they thought he was intoxicated, but the truth is it was just part of his body decaying.
Wow.
So
It just goes to show you that every defense is unique to the person.
All right, Doug.
Absolutely.
You got to come. We're having a whole show with you, okay? So you got to come back, man. We didn't get to it.
We didn't get
Would love
to it.
to.
I mean,
Please.
it's a fascinating story because you just never think about this stuff. We've heard the stories about eating bread and doing the breathalyzer can give a false positive, but creating alcohol within your own body, it just seems
really
so
quickly when you
crazy.
said eating bread. Judge Larry Stanley was at the HBA Bench Bar Conference a few years back when we were
remember
down in
that.
Galveston, and they had the intoxilizer there, and they said, let's test this theory. And he ate a whole bunch of bread, and Troy McKinney was walking him through this. He stuffed his mouth full of bread, chewed it up really fast, and blew as if he'd been drinking.
Wow.
Intoxilizer.
and we know he doesn't drink.
Right.
Yeah.
Right.
Yeah, I mean, it's fascinating. I mean, it just goes to show you stuff like that you have to individually, each person is different. And to defend a case, you have to look at the characteristics of that person and tailor your investigation and your entire defense to that person. Not one shoe fits everybody in this,
Absolutely.
This thing. We got about 30 seconds left, everybody. This has been a great show.
It's quick.
I mean,
Great
you
way
guys,
to start the year.
yeah, it's been a great way to start the year. We got we didn't get to all our topics though. I'm kind of
No.
sad.
No.
We're going to push some to next week.
We got to talk about Al-Qaeda though.
The Al-Qaeda. I mean, Julio, I'm kind of you're running out of things to do now that our Longhorns football season is over.
No, I'm already prepping next year in my
prepping for
head.
next
Yeah, yeah.
That's why he's wearing the A&M colors today.
Oh, whoa,
right.
whoa, whoa!
Yeah,
Hold on now. Hold on.
Exactly. Well, I want to thank you guys, JoAnne, for coming on the show, Doug, coming on the show, Julio, for coming back and joining for another year, signing up for
Amen.
another year of punishment on this thing. I think it's been a good way to kick off the new year, and we appreciate all of you who joined us at home tonight. We encourage you to go check out our website, www.hcclatv.com. Also, check us out on Facebook. Follow us on Twitter. You get all the updates on the show. We'll post live updates tomorrow. You'll get all the clips. We'll get the full episode up. Share it with your friends. Encourage everybody to come watch our show. And for those of you who are involved in Defense Bar, spread the word. Please get us out there. We want more people to watch and get informed on the issues. That's all we got for tonight, everybody. We'll see you right here next week. And we're sure to have another great show. Good night.
Good night.